yesterday, the case where Trump is after birthright citizenship. In order to get at the throat of birthright citizenship, their delivery system will be to argue that federal judges exceed their authority by issuing temporary restraining orders or temporary orders blocking executive policy moves that exist nationwide, that apply nationwide. That's what they're after, and that's what they were after yesterday. And with some interesting arguments. I don't know if we have any sound on any of those. Court, again, this is the media counting on us being uninformed consumers of media. Supreme Court decisions are regularly unanimous. In fact, there was one recently, I think Leonard Kagan wrote for the 9-0 majority. It's in the cases that receive the most relative attention that you see the splits. Yeah. And yesterday's oral arguments were very interesting. Elena Kagan, as you would expect, with Sonia Sotomayor and Ketanji Brown Jackson, really tore into the clownish government lawyers, the Solicitor General, was on the issue of nationwide jurisdiction. Yeah. And as you would expect, the government lawyers really didn't have much to say that made any sense. Ketanji Brown Jackson, does that mean that every time you challenge somebody's birthright citizenship, they got to get a lawyer and go to court? And the government's answer was, well, if it is, that's the way the system is supposed to work. So you see, this is the move. This is classic Trump playbook from his own failed career as a businessman.
It works that way when they want it to work that way.
Okay. Am I mischaracterizing? I don't understand where this idea of universal injunctions comes from in this context.
I think the relevant distinction is an order. That order is, in this case, the government defendant to cease allegedly unlawful activity as to the parties who have come into court and sued, and one that says to the government defendant, cease the allegedly lawful activity against everyone in the entire world.
No, just cease it. Just stop. This thing, this executive order. I mean, we do this in the APA context all the time, right? The statute says you hold that you set aside the conduct, right? That it's unlawful. And we don't really parse it out and say, okay, but it's unlawful only as it applies to the plaintiff or not. So it's a very common concept for the court to enjoin a defendant from doing particular unlawful behavior. And what you're now asking us to do is to require that the court have an additional limitation in its order that says you only have to stop doing this with respect to the plaintiff. And that's the part that I don't understand.
Right. Yeah. Exactly. Yeah. So in other words, you've gone to court because you had to. You've demonstrated you were born in the United States. The court says, okay, you're a citizen. We're not going to overturn all the precedents that lead to that. And then she's asking, so you mean then the court is supposed to go on to say this only applies to you and not to everybody else who has the exact same circumstance? This is what they're after. They want you to have to go to court. Everybody got to court, go to court as individuals.
You said that was one of the first things you said last summer when you were breaking this down in the very beginning of what things could look like in the future. You was like, the point is to get you in the court, drain you so that you can't financially fight on your own behalf. And it's going from corporations down to individuals.
Yeah. And that's what the clown has done in his own failed business career.
Yeah.
You don't like, he just go to court and count on the fact that you ain't got no money.
Yeah. Yeah.
You can pay me. That's all right. Sue me. What? Oh, so you just are out here roguing. Yeah, I mean, you know, to tie the national to the country level to the international level, the clown is out there doing a straight pure grift. $2 billion invested in nothing, meme coins, UAE, Saudis, investing in out of their sovereign wealth form. And then today, the news comes down that they're going to build the biggest AI investment in the United Arab Emirates and ship millions of chips overseas. Now, these are the same chips that the Biden administration said, we don't want those chips going overseas in case they leak to China. Well, the clown got $2 billion in his pocket with his dumb sons running around over there stealing over the last couple of months. And the next thing you know, they announced yesterday that, we're going to build this huge AI venture, this 10 square mile AI plant, artificial intelligence plant in the UAE. And now what are we supposed to do in the United States? It's straight influence peddling, the art of the steal in broad daylight. Yeah. Is it legal? Is it constitutional? Probably not. But guess what? Donald Trump from the Trump playbook, sue me. Let's find out. In the meantime, I'm going to continue. And yesterday was another step, albeit in another area of the law, in that direction by saying that we want to remove any blanket implementation of any judicial order and force you one by one to defend your rights.
We got some more from, now this one is from Justice Sonia Sotomayor. 15, please.
The argument here is that the president is violating an not just one, but by my count, 4 established Supreme Court precedents. We have the one ARC case where we said fealty to a foreign sovereign doesn't defeat your entitlement, your parents' fealty to a foreign sovereign doesn't defeat your entitlement to citizenship as a child. We have another case where we said that even if your parents are here illegally, if you're born here, you're a citizen. We have yet another case that says even if your parents came here and were stopped at the border, but you were born in our territory, you're still a citizen. And we have another case that says even if your parents secured citizenship illegally, you're still a citizen. So as far as I see it, this order violates 4 Supreme Court precedents.
Now, when I hear that, right, in the previous clip, it's the Supreme Court, the highest court of the land, the law of the land, expressing face to face to this administration, you are going against what has been set in place as the highest court of the land. So, however this plays out, what do we, the viewing public, the layperson, the civically challenged, how are we supposed to view these conversations? Because it's like you're the decider, you're the decision maker, and you're telling them that they're doing what they want.
In the law there, and you heard the word there used, in the law there's a concept called precedent. So precedent speaks to how courts interpret statutes. Statutes are what we would generally refer to as laws. Traffic lights, you got to stop at a red light. Okay, why? Because that's the local ordinance. Okay, where did that ordinance come from? Well, the governing body in our town, set this rule. It was passed. We voted on it. Elected officials voted on it. And so now that's the rule. That's the ordinance. That's the law. That's the statute. The originary document, which forms basically the statute, the law for the federal government of the United States, is the U.S. Constitution, ratified 1787. Voted on in 1787, then ratified by the states. Now, each state in the United States of America also has a constitution. In fact, most countries in the world, the overwhelming majority, have constitutions. This is what they call constitutional law, constitutional government, constitutional form of government. And I would say euphemism, the label that most people use as a kind of, sometimes I think it's a non sequitur, but the broad concept that people pursue to talk about constitutional form of government is democracy. Not completely, but generally when people talk about democracy, they really talk about forms of government that have a constitution, that have this overarching set of rules. Now, whose job is it to interpret the meaning of those constitutions? In the United States,
judicial.
That would be the judicial branch of the 3 branches of government. The laws originate in the legislative branch. They make up the laws. They vote on the laws. They are then signed by the executive branch. That would be the president. And when the president disagrees with the legislative branch, the president can veto those laws. If there are enough people in the legislative branch in the Congress who decide that they still want the law, they can override the veto of the president. However, and this was the precedent that was set in place by a case in the 18th century called Marbury versus Madison. The first Chief Justice of the United States of America, John Marshall, in Marbury versus Madison, which was a separation of powers case, wrote, "It is the duty of the courts, it is the function of the courts, it is the role of the judiciary to say, S-A-Y, to say what the law is." Mm-hmm. That's what you heard Sonia Sotomayor referring to yesterday. So when the courts interpret that law, in this case, the Constitution, or any laws made pursuant to the Constitution, like, say, for example, the Voting Rights Act of 1965, which is pursuant to the Constitution, 14th Amendment, 15th Amendment, then that sets what is known as precedent. And when you heard Sotomayor in that clip referring to the Kim case as one of the 4 cases which set into place the precedent that if you are born in the United States, then that means that you are a citizen. That is a case from the late 19th century, 1898, United States versus Wong Kim Ark, known shorthand as the Kim case. Wong Kim Ark was Chinese. Wong Kim Ark was born in San Francisco to Chinese immigrant parents. But Wong Kim Ark went to China with his parents, came back and was denied re-entry into the United States. And they said, "You're not a citizen." Well, he argued, and this is the 14th Amendment of the United States. Here's the law. Let me read it to you. Section 1 of the 14th Amendment writes, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. Now, yesterday when we were talking with Ike, and she was saying if there's a law in one state, the other state has to honor it, the reciprocity argument, the language as it relates to citizenship is here. It's called no state again shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. In this specific case, this was language put in place in the wake of the Dred Scott case of 1857, where they tried to say, I don't care if you were free in what we now call Minnesota, you're in Missouri now, and Missouri is a slave state, so you have to be returned to servitude. And the Supreme Court said there's nowhere in this country where black people have rights that any particular polity has any enforceable right or any enforceable duty to respect. Some people say, well, they say that black people ain't got no rights that anybody is due to respect. No, that means the individual polities. That means if they decide to take away your citizenship in New York State, it's gone because you're black. That's what Justice Roger Taney was saying. Well, the 14th Amendment, legal scholars would argue, was put in place to cure that defect, that birth defect, which is why a lot of people, myself included, would say that the United States of America, as far as African people are concerned, starts to the degree that it ever did with the 14th Amendment. 13th Amendment, 14th Amendment, 15th Amendment. 13th Amendment abolishing captivity unless you've committed a crime, which means they didn't get rid of it completely. The 14th Amendment establishing citizenship and equal protection and due process. And then the 15th Amendment saying if it's going to be an election, everybody gets to vote. Yesterday, they tried to take another bite out of the 15th Amendment through the Voting Rights Act, which is a law passed to enforce the 15th Amendment. And in this case, finally, as you heard Sonia Sotomayor saying to them, we have had 4 cases before the Supreme Court that reaffirmed that the 14th Amendment means if you are born here, you're a citizen. And what you want to do is overturn that? The short answer is yes. The long answer would be, and this is where I'll end, remember the first sentence I read, all persons born or naturalized in the United States. Okay, there it is. Watch this, after the comma, and subject to the jurisdiction thereof. In the Wong Kim Ark case, Wong Kim Ark's parents were not citizens. Right. They had been subject to the jurisdiction of China when they came to the United States. The argument people make is, dumbass, when you come to the United States, you are subject to the laws of the United States. You're subject to the jurisdiction thereof. It's an absurd argument, except these white nationalists are counting on enough people on the Supreme Court to reinterpret that second part of that first sentence, that subject to the jurisdiction thereof. What they're trying to do is get at these people who are born here through their parents, which is why yesterday you heard Ike refer to tourists and you referred to it to tourists. And I'm here, like a baby. And then that baby's a citizen. They're saying, nah, because you weren't subject, so your baby not subject. Don't try to make sense of it, y'all. It doesn't.
That's what
don't try to make sense because it does what they're after.
It doesn't make sense. Yeah.
No, it doesn't make sense. And those precedents were in place because it's the court's job to say what the law is for you to be able to rely on it. But once they start throwing all these precedents out, and by the way, maybe after the break or later on in the hour or next hour, we can talk about another attack that they're going after, because in New Orleans and in Louisiana, they want to get out from under the desegregation statute, saying that their time is past. But we're coming.
Yeah, absolutely. I saw that as well. All right, let's take a quick break. Come right back to it as Urban View Mornings.
More from Urban View Mornings after this on Sirius XM Urban View.
Dr. Greg Carr, Lamont King, and you, 866-801-8255, still talking about the activity from the Supreme Court yesterday. Let's hear from, on clip 12, Brett Kavanaugh, his positioning.
This is just a very practical question, how it's going to work. What do hospitals do with a newborn? What do states do with a newborn?
I don't think they do anything different. What the executive order says in Section 2 is that federal officials do not accept documents that have the wrong designation of citizenship from people who are subject to the executive order.
How are they going to know that?
The states can continue to, the federal officials will have to figure that out.
How?
So you could imagine a number of ways that the federal officials could.
Such as?
Such as they could require a showing of, documentation showing legal presence in the country. For a temporary visitor, for example, they could see whether they're on a B-1 visa, which would exclude kind of the birthright citizenship in that country.
For all the newborns? Is that how it's going to work?
Again, we don't know because the agencies were never given the opportunity to formulate the guidance. They would have 30
They're only going to have 30 days to do this. You think they can get it together in time?
They're under... That's what the executive order instructs them to do, and hopefully they will do so. Again, it's a speculative and hypothetical scenario because they were enjoined from even starting that process.
Right. He's exactly right. That's John Sauer, the Solicitor General of the United States. Let me give you the perfect analogy. Right now, as far as I know, and remind Daryl, Sam, correct me if I'm wrong, but right now I'm not aware of any regulations in place or any really legal jurisdiction for those who are born on the moon to prove citizenship when asked. I'm not aware of any. And if anyone asks, well, how would you do that process? My response to that would be, well, since they've never been required to create these regulations, we don't know how they would do it. That is the exact equivalent of what that fascist white nationalist Solicitor General John Sauer, notice it wasn't even sleight of hand. It was hand-fisted evasion. Now, Brett Kavanaugh is no champion of equality. So when he asks him what to do with newborns, what to do in the case where how you going to carry out this order? Did you hear? Sauer said, "Well, there will be a way. We have to check the paperwork to see if they're in the country legally, if they have B-1 visas." Anybody talking about their parents?
Yeah. We're talking about when they are born.
The amendment says if you are born here, but you see what they're doing. They're trying to move toward that second part of the sentence, subject to the jurisdiction thereof. There is no legal theory that would prop it up, but that. I'm watching my tone. Yeah. That Maryland farmer went right to the parents. At which point you could hear a little bit of irritation in Beer Kavanaugh.
So that's kind of what I was getting at with my previous question. Like, even you got the left leaning judges, you got the right leaning justices, but all three clips we played so far, everybody sounds agitated. Like of course you would expect that from Elena Kagan and Sonia Sotomayor. When you hear Kavanaugh, that's right,
beginning to lean. Right. Well, he's not unsympathetic to the argument that he wants these people out of the country. He just realizes that if they go too far, they're going to reveal the fact. And this is something that I'm sure your pop learned the same thing I learned when I was in law school, Sam. The law is whatever the hell you say it is. The law is about power, not about the fidelity of language, certainly not about a bunch of damn slave owners that wrote a failing 18th century document to protect their property interests and then tacked on 10 amendments called the Bill of Rights. It's like, ooh, we forgot the people. Please understand, what Kavanaugh understands is if you're going to try this bullshit, you better come up with a better rationale. And there isn't one, because they can't get around the 14th Amendment and how it has been interpreted. Not over 100 cases, not over 1,000 cases, not over a century and a half of 1 million different cases, over 4 cases, primarily that United States versus Wong Kim Ark case. It is so clear and has been interpreted as being so clear that nobody ever brings it up. But these clowns have caught the car. And now that they've caught the car, they're going to try to run a Boston on every absurd ass legal theory that they have been dreaming and nurturing in their hearts since black people and white people and Jews and Gentiles and Catholics and Protestants stood on the steps of the Washington Monument and said, you should be judged by the content of your character. And these white boys was like, nah, white people, damn it. This is a white man's country and we're going to fight to the end. And that's when they launched their white lash. The first one after Reconstruction, the second one after the Civil Rights Movement. They done caught the car. They stand at the Supreme Court with this bullshit. And even one of their own was like, hold on.
And then Justice Kagan, and I got to correct myself. I said Ketanji Brown earlier, Justice Ketanji Brown Jackson. But even Justice Kagan was basically like, why are you even here? Fire that one.
You're ignoring the import of my question. I'm suggesting that in a case in which the government is losing constantly, there's nobody else who's going to appeal, they're winning, it's up to you to decide whether to take this case to us. If I were in your shoes, there is no way I'd approach the Supreme Court with this case. So you just keep on losing in the lower courts, and what's supposed to happen to prevent that?
Again, I respectfully disagree with that forecast of the merits, but in response to the question, what I would say is, we have an adversarial system, and if the government is not, for example, not respecting circuit precedent on the court's hypothetical in the Second Circuit, someone injured in the Second Circuit could take the case up, and they could say, look, the government is violating circuit precedent on the hypothetical multiple circuits.
That's the case we're going to take? Somebody who says, after we've said that this all has to be done one by one by one, then we're going to take a case from somebody who objects to proceeding one by one by one?
Thought that was RFK for a minute. RFK Jr., the way he sounded.
Yeah, absolutely. Well, maybe his vocal cords are being choked by all the bullshit.
Yeah, the bad service area.
But again, you heard the evasion.
Yeah, correct. Right.
Yeah. Well, I respectfully disagree as to the outcome on the merits. What he's saying is, oh no, ma'am, We going after birthright citizenship. This is just a link in the chain that is leading us to the ultimate prize, which is to say that the 14th Amendment does not guarantee birthright citizenship. So when she said, basically, everybody got to defend up to the Supreme Court level when you keep losing because this is how we've interpreted the 14th Amendment and that's what the law is. His response is, oh, I don't disagree that that's going to remain the law, lady. What I'm saying, though, is that until we get a chance to smash y'all, by the way, y'all, this is where elections have consequences because the fact that they're even pushing back against this is because he hadn't replaced all the damn judges yet. And believe me, when you look up and see Pam Blondie ass sitting on the Supreme Court, if you let this continue, you're going to realize then that your Boston is complete and y'all might want to be considering making friends again, all you descendants of slaves with your people worldwide, because y'all about to be trapped in a nightmare that you couldn't even have dreamed of while you was out there on the internet vomiting about cut the check and tangibles and all that old bill. By the way, I've heard a lot more of that since the wait, hold on.
No, I ain't heard none of it.
Nothing.
I haven't heard any of it. Yeah.
None of it. None of it. You know, maybe when y'all want to call up here today and we can have an early breakfast on this morning if y'all want to call up.
I haven't even heard that word. I haven't even heard the word. Like in casual
before now, they don't even say it. No way.
Yeah, I haven't even been casual conversation from nobody.
But the one last thing though, now, if the courts do what they often do, certainly the Supreme Court, what they might try to figure out is how to come up with some kind of what is often called middle ground. Mm-hmm. So what might that look like? Maybe the court would rule in June or July, as you said, the ruling will be expected this summer, that, okay, we're not going to allow nationwide injunctions on everything, but for some kind of cases, we will allow it, which means now they're going to have to create some kind of test. The Supreme Court is good for creating tests, balancing tests and 2-prong tests and 3-prong tests. So maybe then they say, well, every federal judge who issues an injunction, think, for example, those of you who remember this since it was so long ago, or I mean, the first Trump term, the so-called Muslim ban. A court in Virginia or a court in Maryland issues, remember when everybody was stuck at DCA and stuck at Dulles and had all the immigration lawyers out there? One federal judge says, nah, we are suspending this ban. That injunction applied not just in Virginia, it applied nationwide. That's what they're after right here. Yeah. They're saying, no, that should only apply in Virginia. So that means I got to go to Houston airport. I mean, I got to go to LAX and JFK and file another one. Yeah. But every time you file it, you lose. Yeah, but that don't mean nothing. That just means you got to keep filing. Well, I just came into Atlanta. I got to file one in Georgia. I just flew into Miami International. I got to file one in Florida. Well, no. So what if they don't appeal? Well, they don't appeal. Somebody will appeal. That's what he telling her yesterday. That's bullshit.
Yeah.
You know what I'm saying? And she said, wait a minute, hold on. You mean that a right that we have affirmed people have, somebody got to appeal and if the court doesn't appeal somebody else? Oh yeah, well, somebody in the, what are you talking about? That's what we heard yesterday was the equivalent in the courts of, what are you talking about?
She said, if I was in your shoes, I would never.
I would never bring this game.
And he's just like, it is what it is, which is the worst, best defense of all time for anything. It is what it is.
Until it isn't. And that's the feat.
And so the last one from, I want to hear 13th. This kind of speaks to my previous question about, they're laying out the law and then the other side is going against it. Then what? So let's hear from Justice Amy Coney Barrett.
Justice Barrett?
General Sauer, I want to ask you about a potential tension. Well, no, not potential tension, an actual tension that I see in answers that you gave to Justice Kavanaugh and Justice Kagan. You resisted Justice Kagan when she asked you whether the government would obey within the Second Circuit a precedent. I'm distinguishing between opinions and judgments here. Did I understand you correctly to tell Justice Kagan that the government wanted to reserve its right to maybe not follow a Second Circuit precedent, say, in New York, because you might disagree with the opinion?
Our general practice is to respect those precedents, but there are circumstances when it is not a categorical practice, and that is not
this administration's practice or the longstanding practice of the federal government. And I'm not talking about in the Fourth Circuit. Are you going to respect a Second Circuit? I'm talking about within the Second Circuit. And can you say, is that this administration's practice or a longstanding one?
As I understand it, longstanding policy of the Department of Justice. Yes, that we generally, as it was phrased to me, generally respect circuit precedent, but not necessarily in every case. And some examples might be a situation where we're litigating to try and get that circuit precedent overruled and so forth.
Well, okay. So I'm not talking about a situation in which, the Second Circuit has a case from 1955 and you think it's time for it to be challenged. That's not what I'm talking about. I'm talking about in this kind of situation. I'm talking about this week, the Second Circuit holds that the executive order is unconstitutional. And then what do you do the next day or the next week?
Generally, we follow those.
So you're still saying generally?
Yes.
And you still think that it's generally the policy, longstanding policy of the federal government to take that approach?
That is my understanding.
Okay. So, but it sounds to me like you accept a Cooper versus Aaron kind kind of situation for the Supreme Court, but not for, say, the Second Circuit? Like where you would respect the opinions and the judgments of the Supreme Court, and you're saying you would respect the judgment, but not necessarily the opinion of a lower court.
And again, I think in the vast majority of instances, our practice has been to respect the opinion as well, in the circuits as well. But my understanding is that has not been a categorical practice in the way respect for the precedents and the judgments of the Supreme Court has been.
So you're not hedging at all with respect to the precedent of this court?
That is correct. I believe the quotation from our application directly addresses that, and we stand by that completely.
So again, when we get to the end of this and there is an outcome, and in a month or so, the court
Before we get there, it is my understanding that when you lose a tooth and put it under a pillow, the tooth fairy comes and puts money under your pillow. It is my understanding.
Mm.
If you're 7 years old and say that, you're absolutely telling the truth because somebody told you that shit and you believe it. What you just heard today was the equivalent of a lawyer telling a justice of the Supreme Court. It is my understanding that there are times when the polity doesn't follow the law. And she said, here's her one-word answer to that. Really? Mm. And then she said, not only this administration, I understand that, but you're saying that generally the executive branch doesn't follow precedent? His response, it is my understanding that generally, and then she said, you're still saying generally. You still haven't given any example of when you didn't follow precedent. I'm not talking about y'all challenging laws from, say, 1955 that you don't like. Understand the Supreme Court decision that came out in 1955? 1954 was Brown versus Board of Education. The Southern states said, go to hell. So what did the Supreme Court do? In 1955, they came back with what is known in the law as Brown 2, which said, we told y'all to desegregate. Clearly, y'all dragging y'all feet and not doing it. So in Brown 2, they said, now we are going to give you some more firm guidance and say that you must desegregate with all deliberate speed. Now, of course, they slow walked for another 10 years, which leads you to the mid-60s, which is why the courts come back and start putting into place desegregation orders and saying, clearly, y'all took all deliberate speed to mean the lifetime of your great-grandchildren. But don't bypass the moment when Amy Coney Barrett, Trump nominee and appointee by the Congress under Trump's nomination, evoked those four numbers, 1955. Right. She took it back to the desegregation of the schools era. It's a lot to suss. I just wanted to make that point.
No. And that's in line with what I was about to ask. So when the outcome happens and whatever decision is made by the court and they strike down whatever they strike down, and then the administration and the Solicitor General just keep doing what they're doing, then what?
Well, this is why you've heard a lot of discussion over the last 6 months. Well, not quite 6 months, but the last several months of Andrew Jackson and the so-called Indian Removal Act. This is when famously Jackson, who had been ordered because of the Indian Removal Act of 1830, he signed that into law in 1830. And that allowed the executive, passed by Congress, signed by the president, it allowed the president to negotiate treaties with the Native Americans, with the indigenous people, because of course in their acts of genocide and purge, they were trying to remove them from the East Coast of the United States to the West Coast. That's what led, of course, to the Trail of Tears. Well, when the courts decide that, the Cherokees resisted, they went to court and they said, these Georgia laws have restricted our freedom on land that's ours by the treaty. And in 1831, in a case before the Supreme Court called Cherokee Nation versus State of Georgia, that same Chief Justice John Marshall, who had wrote for the majority for the Supreme Court in Marbury versus Madison, and said it's the job of the courts to determine what the law is. He said, the Supreme Court said that the Indian Territory is admitted to compose a part of the United States, and he affirmed that the tribes were domestic dependent nations, and their relationship to the United States, resembles that of a ward to a guardian. That's the so-called guardian principle. You hear a lot of people who practice in so-called Indian law talk about this question of the guardian or ward of the state. It's an onerous kind of characterization, but at any rate, my point is this. Jackson said famously, I hear what the court's saying, but do they have an army? And continued.
Yes, correct.
And that's how many of the indigenous people, the so-called 5 civilized tribes, and this is for these descendants of slaves, those of you who called yourselves freedmen, the so-called Cherokee and Seminole freedmen, the captive Africans who also were forced west, who end up in Oklahoma. That's how they end up in Oklahoma. Andrew Jackson, I heard what the court say, but go to hell. And we might be on the verge of another one of those things. That's why people are bringing up the Indian Removal Act of 1830 and the Cherokee and Andrew Jackson. They talk about the clown who was overseas stuffing his pockets with Saudi gold while we over here trying to battle to keep some rights that are always indeterminate.
Yeah. All right. Back after this.
This is Urban View Mornings, weekdays